Hooker, Oklahoma, 1933. Fred Hoeme watched a road construction crew tear up the earth with equipment built to destroy. Their wreckage stayed put in the wind. Meanwhile, his fields blew away like powder. He had plowed them with the prize-winning moldboard that conquered the frontier, but the clean soil stood no chance. What if the plow wasn't failing because of what it did, but because it did too much? What if salvation lay in doing less, in leaving the work unfinished? This observation would set in motion the downfall of the most famous tool in agriculture. It would birth a machine that saved the Great Plains, and it would trigger a Supreme Court case that redefined what counts as innovation in America. This is the story of the CHISEL plow, the ugly tool that rescued millions of acres, then destroyed its inventor's patent in the process. The tyranny of the clean furrow. For thousands of years, farmers believed in one sacred rule: turn the soil. The steel moldboard plow, invented by John Deere in 1837, became the symbol of good farming. It flipped the earth completely over, burying every scrap of plant material and leaving nothing but clean, dark soil. This looked beautiful. Neat furrows stretched to the horizon, soil so perfectly turned it seemed ready to grow anything. Farmers took pride in how clean their fields appeared after plowing, but this beauty came with a hidden cost. Every time a moldboard plow turned the soil, it destroyed the structure that held the ground together. Plant residue that should have protected the surface got buried deep underground. The exposed soil sat naked under the sun and wind. In wet climates, this worked fine. Rain and vegetation kept the soil in place. But on the Great Plains, where rainfall was sparse and winds were relentless, turning the soil was like removing the skin from a living thing. The Dust Bowl of the 1930s proved this in the most devastating way possible. Millions of acres of farmland plowed clean and left bare simply blew away. Farms disappeared. Families abandoned their land. The disaster taught a brutal lesson. The old way of farming was killing the plains. The government promoted strip farming and windbreaks. Farmers terraced hillsides. These helped, but they didn't solve the fundamental problem. Check out our video on the Dust Bowl for a deep dive on what caused it and what they tried. Because even then, the soil still needed protection. And protection meant leaving plant residue on the surface, not burying it. This created an impossible situation. Farmers needed to kill weeds to grow crops, but the only tools they had were plows that buried everything, leaving the soil exposed again. It was a vicious cycle with no apparent solution. Enter Charles Noble. By 1935, he was farming about 8,000 acres in southern Alberta, in the heart of the dry belt. He watched his neighbors struggle with the same problem. How do you control weeds without destroying the soil? Noble understood the stakes firsthand. In his earlier years, he had owned 30,000 acres in southern Alberta, but financial troubles during the years of poor crops in the 1920s had forced him to surrender most holdings. By 1935, he had rebuilt to about 8,000 acres, and he was not about to lose them again. Then he took a trip to California that changed everything. A single trip, watching a sugar beet farmer, revealed a simple, almost unbelievable secret. A secret that would not only save his farm, but change farming forever. What was this simple tool, and why did it work where everything else failed? Noble saw the farmer using a straight blade tool to cut beneath the soil surface, loosening beets for harvest. The blade sliced through the ground without turning it over. It killed weeds by cutting their roots, but left all the plant material on top. Noble had his answer. He returned to Alberta early, his mind racing. In his shop, he took an old grater blade and reshaped it with a borrowed forge and anvil. He attached it to a frame with two stout arms, added wheels and depth control. The first Noble blade was born. It looked nothing like a traditional plow. Instead of a curved mold board designed to flip soil, it featured a straight, flat blade that cut horizontally beneath the surface. The machine was ugly, crude, simple, But when Noble pulled it through his fields, something remarkable happened. The blade sheared weeds and stubble below ground level, killing them at the roots, but everything stayed on top. The residue formed a protective mulch that held moisture and prevented erosion. The soil did not blow away. Noble's blade worked like a surgeon's scalpel beneath the surface, killing weeds without disturbing the protective layer above. A principle that is still saving farmers thousands in fuel costs and preventing erosion on millions of acres today. Noble wasn't alone in his discovery. Hundreds of miles south, in the Oklahoma Panhandle, another farmer was having the exact same realization. Fred Hoeme ran a farm near Hooker, Oklahoma, right in the heart of what had been the Dust Bowl. He had watched his land blow away in the 1930s. By 1933, he knew something had to change. Hoeme built his own version of an underground blade. Like Noble, he designed it to cut weeds beneath the surface while leaving residue on top. His machine was heavier, built to handle the tough, compacted soils of the southern plains. By 1938, Hoeme had sold 2,000 units from his farmstead. Farmers desperate to save their land grabbed onto anything that might work. The Hoeme plow proved itself in the harshest conditions imaginable. Then came W.T. Graham. Graham was a businessman from Amarillo, Texas, who saw potential beyond a farmer's workshop. In 1938, he purchased the manufacturing and distribution rights. Graham understood something crucial. This was not just a local solution for desperate Oklahoma farmers. This was technology that could change agriculture across the entire Great Plains. He had the capital, the connections, and the vision to turn a farmer's invention into an industrial product. Graham did not just manufacture plows, he built a brand. The Graham Hoeme name became synonymous with soil conservation. His marketing emphasized the disaster everyone remembered, the Dust Bowl. Buy this plow, save your land. The message resonated. He rebranded it with a bold claim, the plow to save the plains, and the line stuck. The timing could not have been better. The 1950s brought another severe drought to the plains. Farmers who remembered the Dust Bowl panicked. They needed a solution, and they needed it fast. It was not an exaggeration. During the 7-year drought of the 1950s, the Graham Hoeme plow stopped erosion in its tracks. Farmers who used it watched their neighbors' fields blow away while their own stayed put. The plant residue on the surface acted like armor, protecting the soil from wind and sun. By the mid-1950s, an estimated half of all Great Plains farmers owned CHISEL plows. The machines came in various sizes and configurations, but they all worked on the same principle: disturb the soil as little as possible while killing weeds. The technology spread globally. Farmers in Australia, Canada, and South America adopted similar designs. The CHISEL plow became one of the most important agricultural innovations of the 20th century. But success attracted competition. Other manufacturers watched Graham's profits and wanted their share. John Deere, the giant of farm equipment, began producing its own CHISEL plow, utilizing similar principles. Graham had filed for patents on his design improvements, specifically regarding the vibrating Shank mechanism. He believed those patents protected his market dominance. In 1965, Graham sued John Deere for patent infringement. He thought he had a solid case. The district court initially agreed with him, upholding the patent and finding in Graham's favor. But John Deere appealed to the Eighth Circuit Court of Appeals, arguing that Graham's invention was merely an obvious combination of existing parts. And that is where everything changed. Graham had made real improvements to Home's original design. He filed for a patent in 1947 on what he called a vibrating plow. The innovation, he claimed, was adding pronounced pumping or vibratory action to the ground-working tools. This vibration, Graham argued, made the plow more effective. It worked fine soils toward the bottom to form the seed bed. It pushed coarse materials to the top for better mulch. It created alternating pockets and ridges in the furrows that collected and stored moisture. Most importantly, Graham claimed the vibration made the plow easier to pull. Less motive power was required. That meant farmers could use smaller tractors. The patent examiner agreed. On January 10, 1950, Graham received his patent, which centered on one specific claim. The vibrating action of the plow shanks made his design superior to earlier chisel plows. This was not just marketing talk. Graham had observed something real in the field. When the shanks vibrated as they moved through the soil, the plow worked differently than a rigid blade. The vibration created a pumping motion. As the shank flexed up and down, it pushed fine soil particles downward while bringing coarser materials to the surface. This produced a better seed bed underneath and better mulch on top. The vibration also reduced draft. A rigid blade cutting through the soil encounters constant resistance. A vibrating blade, flexing with the contours of the ground and obstacles, required less pulling force. Farmers could use smaller tractors, saving fuel and equipment costs. Graham's original patent, United States Patent 2,493,811 from 1950, covered this basic vibrating plow design. The shanks were mounted above a hinge plate, allowing them to flex freely. But Graham did not stop there. Shortly after receiving that patent, he made an improvement. He moved the hinge plate from above the shank to below it. This repositioning minimized the outward motion of the shank away from the plate, making the vibration more efficient. He filed for a second patent on this improvement. In 1953, he received United States Patent 2,627,798. That second patent became the heart of his lawsuit against John Deere. It represented his refined design, the version that dominated the market through the 1950s and early 1960s. Graham believed these patents gave him clear protection. The technology was his. He had developed it, tested it, and patented it. Anyone using vibrating chisel plow technology, he argued, owed him royalties. John Deere disagreed. The company argued that Graham's patents did not cover anything truly innovative. The idea of a chisel plow cutting beneath the soil surface already existed. Fred Hoeme had built one years before Graham got involved. Charles Noble had developed similar technology in Canada. And vibration? Deere's lawyers pointed out that any flexible shank would vibrate when pulled through rocky soil. That was physics, not invention. Graham had not created the vibration. He had just noticed it happening and claimed credit for it. The district court in Missouri sided with Graham. The judge ruled that even if individual elements were not new, combining them in this specific way was innovative enough to deserve patent protection. The court sided with Graham. John Deere appealed. The case moved to the Eighth Circuit Court of Appeals. The appeals court examined the same facts and reached the opposite conclusion. The judges reversed the district court's decision. They declared Graham's 798 patent void. Their reasoning was blunt. The difference between that patent and his earlier patent was trivial. Moving the hinge plate from above the shank to below it was not innovation. It was obvious tinkering. Any competent engineer could have made that change. Graham refused to accept defeat. He appealed to the United States Supreme Court. The Supreme Court showdown. The Supreme Court agreed to hear Graham's case in 1965. It would be argued alongside two other patent disputes, all dealing with the same fundamental question: what counts as innovation? On October 14, 1965, Graham's lawyers stood before the 9 justices. They presented what seemed like a straightforward argument. Graham had improved the chisel plow design. He had moved the hinge plate to a better position. This improvement made the plow work more efficiently, and that deserved patent protection. Justice Hugo Black focused on the core issue: what practical difference did the hinge plate position actually make? The answer, based on the technical evidence, was minimal. It did not fundamentally change how the machine worked or the results it produced. In that moment, the case was essentially over. The justices probed the lack of distinct operational difference. Everyone in the courtroom understood where this was heading. On February 21, 1966, Justice Tom Clark delivered the court's opinion. It was not just a ruling on Graham's patent. It was a complete rethinking of what innovation means in American law. Clark began with history. He explained that Thomas Jefferson, who helped create the first patent law in 1790, was deeply suspicious of monopolies. Jefferson believed patents should only be granted for genuine advances in technology, not for minor improvements or obvious changes. This philosophy was embedded in the Constitution itself. The Patent Clause grants Congress the power to promote progress in science and useful arts. Not to reward inventors for their effort, not to protect their moral rights, but to promote progress. For that reason, patents should only cover inventions that would not exist without the incentive of patent protection. Trivial changes do not need patent incentives. Anyone could make them. They do not advance technology in any meaningful way. The 1952 Patent Act had codified this principle in Section 103, requiring that inventions be non-obvious to receive patent protection. But what did non-obvious actually mean? Clark laid out a test. To determine if something is obvious, courts must examine three factors: the scope and content of prior art, the differences between the prior art and the claimed invention, and the level of ordinary skill in the field. Then Clark added secondary considerations. Commercial success might suggest non-obviousness. So might long-felt but unsolved needs, or the failure of others to find the same solution. These factors became known as the Graham factors. They would guide patent law for the next 6 decades. Applied to Graham's patent, the test was devastating. The prior art included Graham's own earlier patent, Fred Hoeme's Plow, and Charles Noble's blade. The difference between Graham's 798 patent and this prior art was simply the position of a hinge plate. Would this change have been obvious to someone with ordinary skill in agricultural equipment design? The court said yes. Moving a hinge plate from one position to another was exactly the kind of routine engineering that did not deserve patent protection. Graham lost unanimously. 7 justices joined Clark's opinion. 2 did not participate in the decision. The CHISEL plow that saved the Great Plains could not be patented, not because it was not important, not because it was not valuable, but because the specific improvement Graham claimed was too obvious to count as innovation. The agricultural victory. The Supreme Court took away Graham's patent, but it could not take away what the CHISEL plow had accomplished. By the time the court issued its ruling in 1966, chisel plowing had fundamentally changed agriculture across the Great Plains. The technology Graham tried to protect had already won its most important battle, saving the soil. During the drought in the 1950s, farmers with chisel plows watched their fields stay put, while conventionally plowed land blew away. The difference was stark enough that skeptics became believers overnight. Word spread farm to farm, county to county, state to state. The numbers told the story. In 1950, almost no one used chisel plows. By 1960, half the farmers in the Great Plains owned one. The adoption rate was faster than almost any agricultural technology in history. This was not just about stopping erosion. The chisel plow changed how farmers thought about their land. For the first time, they understood that soil was something to protect, not just turn over. Plant residue became valuable instead of trash to bury. The shift laid the groundwork for what would become conservation tillage and eventually no-till farming. But the road was not smooth. The chisel plow's success pointed toward an even more radical approach. In 1953, International Harvester launched the first commercial no-till planter, the M21. It could plant directly into undisturbed soil without any tillage. But after just 2 years, They pulled it from the market. The problem was not the planter. It was the weeds. Without herbicides to control them, farmers had no choice but to keep tilling. The chemistry had not caught up to the engineering yet. Today, millions of acres worldwide are farmed with minimal soil disturbance. Crop residue stays on the surface. The soil structure remains intact. Charles Noble's blade, Fred Hoeme's plow, and Graham's improvements all contributed to this revolution. They proved that farming did not require destroying the soil to be productive. The legal defeat did not stop innovation in chisel plow design. Without patent protection, manufacturers competed on quality and features. John Deere, Case, International Harvester, and dozens of smaller companies all produced versions. Competition drove improvements. Modern chisel plows bear little resemblance to Graham's original design. GPS guidance systems control depth precisely. Hydraulic systems adjust on the fly. But the core principle remains unchanged. Cut weeds beneath the surface, leave residue on top. The Graham case itself became more influential than Graham's patent ever could have been. The test Justice Clark established guides patent law to this day. The Graham factors appear in thousands of court decisions. Every patent examiner learns them. Every patent attorney studies them. Graham lost his case, but won something bigger. His lawsuit forced the Supreme Court to clarify what innovation means in America. That clarity benefits everyone who invents, everyone who manufactures, everyone who uses technology. The chisel plow saved the plains. The Supreme Court case saved patent law from drowning in trivial claims. Want more stories about the inventions that saved farming? Subscribe for deep dives into agricultural history, engineering breakthroughs, and the people behind them.